They can't arrest you for no reason, can they? The Fifth Amendment to the U.S. Constitution says that no person shall be deprived of life, liberty, or property without due process of law. And the Fourth Amendment says that the right of the people to be secure in their persons against unreasonable searches and seizures shall not be violated, and no warrants shall issue but on probable cause supported by oath or affirmation. So what does it mean to get this due process of law? The intent of the United States founding fathers was that there is supposed to be a series of checks in place to ensure that innocent people don't get arrested, held in jail, or put on trial without several protective layers of scrutiny. So how does it work? First, warrants. Generally speaking, police can't arrest a person unless they've gone before a judge, swearing that a person committed a crime and showing the judge sufficient evidence that the person probably committed the crime. This is important. Magistrate judges are elected officials, so in theory, they're accountable to the people, and they should know the law. This is very different from the police, who usually aren't educated in the law and are just hired by the city. The requirement for a judge to issue a warrant is supposed to restrain police from making arrests for no reason. But in practice, it really doesn't work that way because of an emergency exception to the rule that has gotten way out of hand. At the time of the American Revolution, the English common law allowed a person to make an arrest without a warrant if he witnessed the commission of a felony or breach of the peace in progress. At the time, felonies were crimes serious enough to justify death, and a breach of the peace was an act of violence or threatened violence. There also weren't any police back then. So the rule was that if an ordinary person saw that violence or murder or that kind of immediate danger had broken out, he could restrain the person and bring him to the judge first and get a warrant afterward. And this continued under the new Constitution. As time went on, this emergency situation was expanded. The definition of felony changed from crimes carrying the death penalty to include anything with a penalty of more than 1 year behind bars. And as punishments became more harsh, more and more things were added to the list of felonies. Then, local governments started employing police forces, and eventually, police were given enough power to make arrests for just about anything, as long as they went to the judge to get a warrant after the fact. We would hope that police would show restraint and would only make arrests when absolutely necessary. But as we've all seen, they're more likely to look for reasons to arrest people and are more than willing to lie to do so. And in Georgia, getting a warrant after committing an unlawful arrest is stupidly easy. Take, for example, the Home Depot case we covered in Season 1. In that case, a judge issued a warrant against Elder Freeman for simple assault on June 30th, 1 day after Freeman was arrested, apparently with no evidence at all except for Donnie Nelson's police report. The rationale for granting the warrant references nothing except for the text of Nelson's police report, copied and pasted verbatim, spelling and grammatical errors and all. No other witnesses are mentioned, and we know that investigators did not have the Home Depot security footage until a few days later. So apparently, anything an officer writes in a police report is sufficient for a judge to issue a warrant. And I say a judge because we don't even know what judge issued the warrants in the Home Depot case. The warrants we received from the district attorney's office have no names or signatures on them. Also interesting, police did not seek a warrant for Elder Freeman's supposed disorderly conduct in the Home Depot until 10 days after his simple assault warrant. Several days after investigators received definitive video evidence proving Freeman's innocence of simple assault. This could suggest that someone intentionally invented the false disorderly conduct charge to justify the stop because they knew their original rationale could not hold water. Unfortunately, the court's documentation is so sloppy, we don't even know who applied for the warrant. So the Bill of Rights supposedly guarantees you a right not to be arrested without a warrant issued by a judge after the showing of evidence and establishment of probable cause. But in practice, a police officer can arrest you for literally anything or nothing, and then he can write whatever he wants in a police report, and some anonymous judge, without looking at any evidence, will presume that there is probable cause to hold you in jail. I'm Mr. Pipsqueak signing off, and remember, you should never talk to police without your parents and a lawyer present.